shifts to the United Kingdom and the United States, or more specifically, the jurisdictions of England and Wales and the state of Illinois. I'm going to be speaking from the English and Welsh perspective. I see there's an awful lot of familiar faces on screen right now, but for those who've not previously met me, my name's Ian Denham. I'm a barrister out of Temple Chambers in London, specialising in personal injury, cross-border claims and clinical negligence claims. I'm also pleased to introduce our friends from across the Atlantic. We have Jack and Sarah speaking today. They're plaintiff lawyers specialising in medical malpractice claims. Some of you may remember Jack, who spoke at the Young Lawyers Conference in Manchester last year. And we're pleased to extend our relationship with Clifford Law by bringing and welcoming Sarah to PEOPIL as well.
Great to be here. Thanks for having me.
So moving forward, in terms of the theme from the English and Welsh perspective, and we're looking at a particular focus on clinical negligence claims, medical malpractice claims. The impact on all jurisdictions, legal jurisdictions, has been profound as a result of the coronavirus outbreak. As of a couple of days ago, the United Kingdom passed the threshold of 20,000 deaths, and I heard this morning that our deaths have surpassed Spain. They are deaths that have been recorded in hospital as attributed to COVID-19. They don't include those who've died at home or at care homes. And the real concern at the moment relates to care homes, and it's feared that the number may well be much higher. The United Kingdom remains under lockdown. Social distancing is the norm. We're allowed out for 1 hour's exercise a day. We're allowed out to shop, and we're allowed out to work if we can't work from home. And there's an example of Altrincham bus and train station where they've taped up the seats to ensure that people can't sit next to each other. And we're getting very used to the concept of social distancing and keeping a clear 2 meters away from each other. Initially, we had a burst of panic buying. Pasta and toilet rolls in the United Kingdom became scarce resources. But the main concern now is shifting to limiting the spread of the virus, looking after our healthcare workers, and considering what the best way is of moving down in the lockdown to avoid the notorious second wave of the virus occurring. In terms of the impact of the virus on the courts and litigation system in the United Kingdom, that's the Royal Courts of Justice in that photograph, and it's also a mock-up of the Royal Courts of Justice that appears behind me. When I speak to European colleagues, they're often surprised how often lawyers in the United Kingdom attend court. We're often in court multiple times a week. And since the lockdown, all courts are shut. There's a minority of courts that are open for judges to attend. Some are working remotely, and that's had a huge impact on both the solicitor's profession and the English bar. A large amount of court hearings and trials have been vacated, and when they'll be listed again is anybody's guess. We simply at the moment don't know when the lockdown period is going to come to an end. The court service and lawyers have been rapidly trying to adapt to existing technologies. There's an existing use of telephone hearings, which has needed a greater use of PDF and e-bundling to get evidence to the court and to each other, and adapting to use of Skype, Microsoft Teams, and the courts are now developing their own video and file sharing technology that's hopefully going to be rolled out soon. The courts have been prioritising keeping longer trials going, and there was a report only a couple of weeks ago that an attempt by the parties to get a 5-week listed trial vacated had failed. And the reason for that is usually these bigger cases are of higher value. Greater resources can be ploughed into them in terms of the use of technology to get the cases going ahead. But quite frankly, the court's diaries are so busy over the next 18 months, finding another slot for everybody to be available for a 5-week trial in the future is going to be nigh on impossible. Lawyers are juggling multiple roles. All lawyers are effectively working from home. They're not working with the resources that they're used to, and many are juggling work, home life, parenting, schooling, and the stress of social isolation. But we're doing our best. Other than court closures and the stress of home working, other impacts on litigation have included the cancellation and postponement of medical legal examinations. It's just not possible for claimants to go and see doctors to have their examination. Likewise, most medics, or a great deal of them, are not going to be available to provide examinations, as their focus has shifted to the front line to provide medical services, whether or not directly or indirectly addressing this crisis. Those of us who do cross-border work are also facing the struggle, quite simply, of getting evidence from various countries abroad which are facing similar, if not more extensive lockdowns. And it's just simply not possible to get that kind of information at the time. The result has been that court directions and timetables have had to be revised. Our civil procedure rules have been amended to take into account the realities of the situations. And there's also been a practical impact upon firms, both on the claimant side and the insurance side. Lawyers, loss adjusters and the like have been put on furlough. And in terms of the cash stream for firms, most claimant cases are brought on a conditional fee agreement basis, no win, no fee. If the case can't get to trial and the case can't be resolved, that's going to necessarily delay settlements, compromise of cases and cash streams. Moving on to the direct impact of clinical negligence claims. I'm a lawyer, so I'm going to give a caveat at the outset. This is intended to be a summary of the possible effects on clinical negligence claims. Clinical negligence claims is a very broad and complex topic, and in about the 20 minutes I've got, it's going to be impossible to deal with all of the various issues on how the virus will impact upon this area of work. Furthermore, we're far from understanding the true nature of the virus or its impact upon society generally, let alone the legal sector. Is it too soon, we might ask, to be discussing these issues? Well, as lawyers, it's my opinion that we have to be pragmatic and consider the challenges that are facing us moving forward. So having a dialogue at this stage and considering these issues as we face the issues confronting us, I consider to be a sensible issue. That said, all of us in the United Kingdom are very grateful to our health service. 11 o'clock on Tuesday morning, the nation fell silent to remember those who have died as a result of the outbreak. And what I'm showing you on the screen right now is what happens at 8 o'clock in the evening every Thursday. Everybody goes to their front door, goes to the window, goes to their balconies and applauds the carers and the National Health Service. And we can see there some of the good folk of the United Kingdom excitedly clapping on our NHS heroes. An interesting issue that has arisen is the question of indemnity and immunity for healthcare workers in the United Kingdom. As a result of the outbreak, the British government has enacted the Coronavirus Act 2020. It's wide-ranging legislation, but part of its scope under sections 11 to 13 allows for the government to indemnify trusts and healthcare workers in England, Scotland and Northern Ireland, those being the three legal jurisdictions within the United Kingdom, with regards to medical negligence claims arising from the treatment of coronavirus and out of the outbreak generally. That's because we have individual trusts that will have individual liabilities for negligence claims rather than the overarching NHS. And that's been brought in to provide financial security and reassurance for those medical practitioners. It's not a grant of immunity, however, and it's hoped and assumed that the United Kingdom's government will not grant healthcare workers an immunity for medical malpractice arising from the coronavirus directly or indirectly. However, the Medical Defence Union, an organisation that provides legal support and indemnity to medical professionals in the UK for alleged medical malpractice, has called for doctors to be granted an immunity from negligence claims arising from the treatment delivered during the coronavirus outbreak. So that's not just directly related to the treatment of coronavirus, but everything going on during this window of time. They argue that doctors should be spared the stress and anxiety of medical negligence claims. My personal view is that it's unlikely that step will be taken, but if it were, it would be wholly unreasonable. The crisis should not grant medical professionals a license to act negligently. And it's my view that the existing common law principles under English law are sufficiently flexible and robust to take into account the unique circumstances in which we find ourselves. How will the law do this? Well, principally through taking into account context. Parties to a potential negligence claim will need to consider the context in which the alleged negligence arose. This does not require, in my view, a specific change to the law itself. The common law system is made up of decisions of the courts and is not, it's not like in some of the civil law jurisdictions prescribed by a civil code. And that allows it to be flexible, robust, yet nuanced to take into account the crisis. And with all negligence claims, the following questions will be asked. Was there a duty? What was its scope? Was there a breach of that duty? And did the breach cause the injury, loss, and damage that's been alleged? In addition, we have what's known as the Boland test. This requires the court to have regard to how the conduct of healthcare professionals measures against the standards of responsible bodies of relevant professionals. So there's various checks and measures that exist and series of questions that can be adapted to the particular circumstances. A key issue in determining what the nature of a duty of care is, whether or not it was breached, and questions as to causation lay with medical evidence. That evidence will need to consider, with regards to the outbreak, particular demands on clinicians, the resources that were available, and the number of patients and their needs. That's going to have a real impact, I think, on the content of medical legal reports. And I'm going to suggest that having a recent medical experience or even active clinical experience during the course of this outbreak is going to become a more relevant and obvious factor. An expert who can speak to clinical practice during the course of this virus, rather than in the abstract, is more likely to be a more compelling and persuasive witness as to what the realities were. They'll need to answer questions with regard to resources. What personnel were available? What level of experience of clinicians were available? A key question in the NHS right now, what equipment was available? There's a huge debate about why we didn't sign up to an EU package of buying equipment. We didn't do it, and there's an argument that we're suffering a shortfall as a result. What medications were available? What practical pressures were there? Doctors are known for working around the clock anyway, but at these stages, they're working for longer hours. How many patients do they need to treat? What constraints exist? What advice is out there? What priorities had to be made? They're all relevant factors. There's also going to be a question as to whether or not there should be differing standards on the basis of recruits which are being brought into the NHS. Final year medical students and final year nursing students are being brought directly into practice now, and retired clinicians are also returning to the front line. In fact, I was only listening to a seminar the other week from a retired spinal surgeon who'd volunteered to go forward to help on the front line, only to be allocated working in a morgue in the Bristol area. But nonetheless, you're going to have professionals whose training is either incomplete or whose experience is now out of date to potentially current measures. And we'll have to think about that. On a lighter note, I learned yesterday that there is still a 98-year-old GP working in Paris. This is Dr. Christian Chenet, who not only must be commended for continuing to work until the age of 98 years old, but is still going out and helping his patients in Paris despite the risks individually to himself of contracting the virus. Another issue is delay in treatment, and in my view, this is twofold. There are those whose treatment, those who've been directly contracted the virus with regards to questions of delay of diagnosis and delay of treatment, and what implications that may have had with regards to their health and questions of mortality. The wider group of individuals who are likely to be affected are those who are indirectly affected. And there might, for example, be somebody who's waiting for a knee replacement operation. Well, with regards to those, it may well be that there's not going to be much prospects of a successful claim. Yes, they may suffer for a period of increased pain or discomfort or reduced mobility. But the more significant numbers are those who have more pressing needs. And the most obvious example are going to be cancer patients and the delay in cancer treatment. The Guardian estimated 2 days ago that over 18,000 more deaths are predicted as a result of a delay in treatment or misdiagnosis. And that again is going to raise questions about resources, official guidance, and possibly some unsavory priorities that may need to be made. Will there be discrimination between young and old, fit and obese, smokers and non-smokers, those with pre-existing health complaints and those apparently with not? I also think there's going to be an issue with regards to the question of causation. An obvious case of a misdiagnosis of a cancerous condition will still be negligence. But there still may be arguments that, notwithstanding that negligence with regards to the question of a failure to properly diagnose, there was simply not the resources to be able to treat that condition in the appropriate time, and that it may be argued that it didn't make any difference in any event. And these are the sad realities due to the constraints and pressures that are currently being imposed on our health service that may well become realities. And what was previously may have been seen as an inexcusable delay in investigation or treatment may become regarded as acceptable in these unusual times. Each case will determine on its own facts, but I think a lot of cases will need to be viewed differently as a result of the situation in which we find ourselves. Returning to the issue of the effect on litigation itself, I've already highlighted that there's been delays in issues of cases being concluded and resolved. Litigation can be a particularly stressful experience on claimants, and these delays and the uncertainty as to how their case will be resolved won't help those concerns either. There's the growing backlog with regard to hearings and trials. Regularly, I'll have a trial in my diary, only to be told usually about 3 or 4 days beforehand, no, it's not going ahead. I had a 5-day clinical negligence trial in my diary that was due to start next week. That's gone. The courts are doing their best, but clinical negligence claims are going to be even more susceptible to those adjournments. There's going to be delays in obtaining medical evidence. There's going to be delays in experts being able to finish off their reports, being able to respond to questions and producing joint reports. A lot of that's going to be due to the fact that a lot of medico-legal experts have returned to the front line. And all you need to do from the British audience, if I follow Ilan Lieberman on LinkedIn, a pain expert who's gone back to the front line, and his messages on LinkedIn about what the front line are like are truly disturbing. And you can see that he's not going to be turning around pain reports anytime soon, or if he is, he's going to be struggling to do it. And quite simply, medics are not going to be available to attend trial now or in the foreseeable future. How do we deal with this? Well, parties are being urged to be less adversarial and more cooperative in their ways. And it may well be that parties will need to consider resorting to alternative dispute resolution or mediation as a way to either cut through and narrow issues or to resolve claims. Are there going to be less claims? Well, we're not going to be able to know until 2 or 3 years' time at the very earliest, but I suspect there may be a drop in the number of claims. Firstly, I think there may well be a reluctance to sue the NHS. The government has been doing a fantastic job at trumpeting the efforts, as have all the major media outlets. I think for some individuals, they'll just feel that they just don't want to sue the NHS. But also due to the contextual issues which I've discussed, I think that there'll be a question with regards to were cases that would have been considered good or even strong in the past now have the reasonable prospects for claimant firms to run on a conditional fee agreement basis. And it may well be that some cases fall at that hurdle, and will also be the question of proportionality, with being able to regard to push certain cases forward. And it may well be that it would only be justified to run the more risky high value cases in the new world that we find ourselves in. That's everything from England and Wales. Thank you very much. Stay safe, and if you've got any questions for me at the end, I'll be happy to deal with them.